Welcome, and thank you for joining us for today's webinar, Keeping Pace with Washington, the latest Department of Labor updates affecting retirement plans. Before we jump into today's session, let's review a few introductory details. If you have any questions as we go, drop them in the chat box and we'll get to as many as we can during today's session. We're also recording this, so if you want to revisit any topics we discuss or like to share it with your team later, we'll send everyone the replay link tomorrow. At the end of our discussion, a short survey will appear. It only takes a moment to fill out, and your feedback helps us shape future conversations that deliver the guidance and clarity you expect from Hub. Now, I have the pleasure of introducing you to our speaker today, Bradford Campbell. Brad concentrates his practice in employee benefits advisory, specializing in ERISA Title I issues, including fiduciary conduct and prohibited transactions. He also serves as an expert witness in ERISA litigation. He is a former Assistant Secretary of Labor for Employee Benefits and head of the Employee Benefits Secretary Administration, and is currently a partner with Baker Drinker Biddle Reath. Thank you, Brad, for joining us today.
Well, thanks, Amber. And more importantly, thanks to all of you for taking the time out of your day to join us. I suspect I know why you're here, and that's because DOL has, as always in this administration, wasted no time in putting out some major new news. Since the last time we got together, a lot of things have been happening. And so we thought we would go through some of those today and get you kind of the lowdown on what's really happening and, more importantly, what some of it means. So thought we'd start out, of course, talking about the Department of Labor's new regulation. I say new, I mean, we're about 2 months into the proposal, roughly, but the comment period is just ending and all of that's coming together. People are still coming to grips with what it means and what it doesn't. And we'll talk about its implications, its practical effects. Also want to give you a little update on the enforcement side, because DOL has made some reforms and they've announced some new policies and procedures that are really going to affect plans and how they go forward in doing investigations. And it's worth focusing on what DOL is changing about its enforcement policy. And the last thing we thought we'd discuss today is that the DOL's put out some new guidance on proxy voting and indirectly kind of on ESG issues, all of which we just need to be aware of as we go forward and deal with how do you vote the shares that are, as DOL puts it, pertinent to the investments your plan holds. Do you need to vote them? Who's voting them? Are you watching who's watching voting them? All of those questions. So let's jump right into the new fiduciary safe harbor proposal. And some folks are calling this the alternative investments proposal. Some folks, like myself, are calling it the fiduciary safe harbor proposal. And that's because there's been kind of an interesting path that's led us to what this is, and it does something different than what I think everyone was originally expecting. Just to kind of review the bidding here, last fall, President Trump issued an executive order that dealt with alternative assets. And what it essentially said is, hey, Department of Labor, why is it that other institutional investors use alternative assets fairly widely, but defined contribution plans don't? I'd like you to look into that and issue guidance or regulations as appropriate to address that issue. And in that executive order, the president identified 6 particular types of alternative assets for DOL to look at. Well, DOL went to work on a regulation, and they now, at the end of March, put out that regulation as a proposal and are taking public comments on the proposal. And even though it was about alternative assets in the executive order, the proposal is actually about something much broader. It also addresses alternative assets, but it's even more broadly creating a universal fiduciary safe harbor process that you can use when selecting investments for defined contribution individual account plans. In other words, it's a proposal that says, if you follow the criteria we've laid out, and they gave 6 particular factors that need to be considered, if you appropriately consider those 6 factors when making a decision about what the core menu of your 401k plan is going to be, then you will be deemed to have fulfilled your duty of prudence. In other words, it's a safe harbor for a prudent process. If you follow the elements DOL's laid out in this proposal, then you would be deemed, in their view, to have complied with your duty of prudence. It also, on the alternative front, did address that by saying that ERISA is agnostic as to types of investments. Basically, their view is, and I think this is consistent with the long statutory and case law history of ERISA, they said, look, ERISA doesn't favor or disfavor any kind of legal asset. If it's otherwise legal, you can have it in your plan as long as it's prudent. And I think that's where a lot of the debate on alternatives is going to come down to, is a particular alternative asset prudent to include, and if so, how? And so this regulation is really proposing one, and I put one for the safe harbor first, because it really is the core of this regulatory proposal. How do you prudently select any investment for your 401k plan? And then secondly, specific issues related to alternatives, indicating that, yes, you can have alternatives, but they still have to be prudent. And I think there's a lot of interesting ways they've set this proposal up. So, for example, what they've done is they've taken really long established ERISA principles. Things like you don't have the duty to pay the cheapest fee, you have a duty to pay a reasonable fee. Things like your fiduciary process is what you're judged on, not whether your investment ultimately loses money or makes money. You know, ERISA fiduciaries aren't judged in hindsight. They are judged by how they make a decision, not by whether the markets ultimately go up and down and their decision is technically right or wrong. And that's counterintuitive, I think, for a lot of folks to think about, but that is absolutely how ERISA works. It's how the courts have interpreted ERISA historically. And so DOL has taken about 6 or so of these concepts that are themselves well established and not controversial, and they've woven them into this new structure of the actual safe harbor they're proposing. And that is something that's kind of new, and that is something that's controversial. In terms of why they're doing this, I think that's what's really interesting. They were very transparent about why they're doing this, and it's not actually about alternative investments. Again, it's kind of a smaller part of this proposal. What it's really about is ERISA litigation. It's about DOL saying we want to reduce litigation against plan sponsors and fiduciaries who are making reasonable decisions and following a prudent, thorough, well-documented process. And so I've got here a quote from the actual regulatory text, their proposed regulation, not the regulatory text, but the preamble, where they explain why they're doing what they're doing. And they say, look, the overarching goal is to alleviate regulatory burdens and litigation risk. And this is kind of spicy language for a regulation, but it says, you know, this is achieved by clarifying that fiduciaries, not opportunistic trial lawyers, have the discretion to make these investment decisions. And we want to reiterate that this is a law. ERISA is grounded in process, that it gives maximum discretion and flexibility to plan fiduciaries, and that arbiters of disputes, in other words, judges, should defer to fiduciaries under a presumption of prudence where they've actually complied with that procedural prudence, where they've followed the right process. And that's really what DOL is doing in this proposal. Again, they're very transparent about saying that here. So I mentioned that there are these long-established principles they've woven together to make this new proposal. And it really builds on the existing regulation. The regulation that governs how you select investment alternatives dates back to 1979. And it says that you have to prudently consider all relevant factors when making an investment decision. And they have kept that. What they're doing is expanding on it to say what 6 of the particular relevant factors are that are common to all investment decisions. And they give 20 examples to illustrate how to apply those 6 principles. And essentially what they're saying is we want to, by regulation, create a safe harbor that courts should use to give deference to fiduciaries, because what we're saying this safe harbor is, we're saying that's the process that should be followed. And when you follow it, you shouldn't be second guessed on the details, that you have met the burden of prudence that the law is imposing on you. Now, where this safe harbor that DOL is proposing differs from existing safe harbors is that most safe harbors out there have a statutory root, right? So if you think of selecting a QDIA, there is a statute, the Pension Protection Act, which amended ERISA to create a safe harbor for automatic enrollment. And it directed DOL to issue a regulation to give all the form and detail to that safe harbor. So when you select a QDIA, when you follow the QDIA regulation, that is DOL's regulation implementing a statutory safe harbor. And that's also what's going on with the safe harbor for selecting an annuity provider. That's in the Secure Act. Where this is different is DOL is saying, hey, we're going to use our general regulatory authority. There isn't a specific statutory commandment to do this, but we're going to use our general regulatory authority to create a safe harbor that you all can use. And so one of the questions is going to be, how is that all going to be received? How is that actually going to work? But first, let's spend a second talking about what the elements of the safe harbor are. And essentially what it says is you have to objectively, thoroughly, and analytically evaluate at least 6 particular factors. Performance net of fees is one of those. Fees themselves is one of them. Liquidity, in other words, if I select this investment, how will it affect the ability of the plan and of the participants to get in and out of the investment? Valuation, is this an investment that we're able to ascertain values as we need to for our defined contribution plan for participants and plans to get in and out of the investment? We have to find a meaningful benchmark to compare it to, and they spend a lot of time talking about that issue. For example, what is the right thing to compare your target date fund that you might be using for your QDIA? What would you compare that to? It's probably not the S&P 500. It's probably a blended return based on the different issues that have gone into constructing that glide path. So they're saying you need to find a meaningful comparator so that you can measure the effectiveness of your investments. And that isn't just some general index. It should be tailored to what your investment is actually doing. And the last one is complexity. And I think as I've gone through these, you're probably thinking, well, gee, we sure do a lot of this already. And I think the reality is, yes, you do. If you have a good fiduciary process, you do already consider all of these issues. The question is, are you considering them and documenting them in the way that you would want to if this safe harbor proposal becomes a final regulation? And I think this last element, complexity, is a great example of that. What DOL says complexity means in the proposal is, do you as an investment committee, the fiduciaries making this decision, do you have the expertise necessary to evaluate these investments? Do you know what it takes? If these are more complex investments, do you understand what they're doing, how they're doing it, what the fees are, all of those questions? And the first threshold is, if we as a plan sponsor, as a plan committee, don't have the information, don't have the skills that we need to evaluate that, then we need to seek that advice and expertise from somewhere else. In other words, you need to hire an advisor to help you do this if you don't have the in-house expertise to do it yourself. And then the second question is, does the advisor have the expertise they need to evaluate these investments and to give you advice and move forward? Now, my guess is all of you have inherently thought about this. All of the plans out there who have an investment advisor have already implicitly decided, yeah, we need assistance in making these decisions, so we hired an expert to help us. But you probably haven't documented it in quite that way. And if you happen to be a plan that does have the in-house expertise, you may not have documented that says, yeah, we looked at this, we do have the in-house expertise, here's what we have, and here's why we believe it's enough. So something like this complexity element of these 6 factors you're considering is something that you've implicitly been doing, but probably not explicitly writing down as a step in your process. And I think that's really going to be one of the key takeaways here, is that we're going to have to respond if this is finalized. And I think DOL will finalize the regulation. This is one of their top regulatory priorities. Again, we're at the beginning of the process, so they've just proposed it. They've just taken comments on it. We're probably looking more like the end of the year before they would finalize this rule. And so maybe in the first quarter of next year, we'd be dealing with implementing it. But in response to this, if the final rule looks similar to what they've proposed, then we're probably going to need to be talking with our advisors and revising our investment policy statements so that they match these elements, so that they consider these elements in the same way that DOL has laid them out in the final rule, assuming we get to a final rule. Also, in the process of doing this, they illustrated how to apply the 6 factors with 20 specific examples. And going back to complexity, I've been kind of joking that this is the full employment for advisors regulation, because of the 20 examples, in every case where the plan got it right, they were using an advisor, and in every case where the plan got it wrong, they weren't. I mean, I think that is one of the lessons to pull from this proposal is if you don't have the in-house expertise, you really do need to engage with an outside expert, in particular, probably an investment advisor to help you work through this. I think DOL is being pretty upfront about saying that that's something that they're kind of expecting to see in response to this. Now, we're going to get a lot of comments. Shortly before the comment period closed, they were already showing about 40,000 comments. And it's fair to point out that most of those actually deal with the alternative asset issue. So this, the question of what should alternatives be considered? What are they? Again, that's in some ways kind of the smaller part of this rule. But I think it is worth mentioning what it is DOL specifically says there. And what DOL says there on alternatives is there is no bias in ERISA for or against any investment. It's about whether it's prudent. And I think one of the things to remember is not all alternatives are created the same, just like not all investments that you would normally think of, mutual funds, collective trusts, insurance products, not all of those are created the same. So for example, just because something is a public investment as opposed to a private investment isn't what's relevant for ERISA. The question is, can it be prudently utilized by your plan? So just as your plan wouldn't, pick a single company stock to be on your menu of your 401k plan, unless of course it's your own stock, and that's a special case where you have qualifying employer securities. But just generically picking on Apple, you wouldn't pick Apple to be a standalone investment on your 401k plan. That would be per se imprudent, again, unless you were Apple. And neither would you pick just generically a particular cryptocurrency. Instead, when we're looking at alternatives, we're looking at the same issues. Is this appropriate for my plan? What are the valuation issues? What are the liquidity issues? What are the fees net of performance? And what's the performance net of fees? What are the fees? Those are all things to consider. And there's a spectrum of alternatives. At one end, just as you might have, adopting crypto into your plan as a standalone investment, which probably is on the imprudent side, you might have, say, a target date fund that in turn is allocating 15 or 20% of its assets to some forms of private markets. That would be something that could address liquidity and fees and all of those issues in that particular type of investment vehicle. And that may well be prudent for your plan to consider. So I think there's a lot of issues being raised in this proposal. One, the safe harbor and what it means, and will courts pay attention to it? And two, to what extent, if any, will a particular plan want to consider alternatives? And so to address that one question, and we've been getting this question a lot, and I'm sure several of you are already furiously typing it away in the comments, will courts pay attention to this? And the answer is yes and no. What I think practically is going to happen is that some courts are going to say, yes, DOL has put together a well-reasoned safe harbor that looks at all the relevant things. We don't disagree with their analysis. So yes, we find it persuasive, and we may well use it in our reasoning. Other courts may look at and find that it's not persuasive. And that's because, as I say on the slide here, how effective will it be? DOL asserts Skidmore deference. That's kind of a shorthand reference to the rules by which courts give deference or not to federal agencies. And in the old days, they used to give more deference to federal agencies, but the Supreme Court changed that standard. So now when a court hears a case that involves an agency rule, they look at it neutrally. They call balls and strikes as they see it. And in practice, I think we're going to see some courts that are persuaded by DOL's arguments in this rule. And I think we'll see other courts that are not as well persuaded. That said, I'll just give my own personal opinion. I'm fairly bullish on this proposal as a protector for fiduciaries who have to make these decisions. Because I think if you say, I've looked at the regulation that was put out by the primary regulatory agency with over 50 years of experience, and I've conformed my actions to its proposed safe harbor, at that point finalized the safe harbor. I've conformed my actions, so I'm doing what they say I ought to do. That should be giving you a very significant amount of cover that you are, in fact, meeting ERISA's requirements and doing things in a prudent way. It doesn't automatically mean that courts are just going to throw away challenges without looking into them. So I think there's still a lot of debate to be had here. We're going to see the full extent of the comments when they come in. We'll have a bit of discussion about that. DOL is going to, as a next step, read all the comments. Then it's got to write a new final rule and then a new economic analysis justifying the final rule. Then it has to send the final rule to other agencies in the White House to get their input, and that's an up to 90-day process there. So as I said before, I think the final rule here is probably around an end of the year-ish time frame. I do think that this is a rule we're all going to be paying attention to, needing to review with our advisors and our plan committees here as an end of this year, first part of next year project, because the amount of change it's posing is significant. Not in the sense that you're doing something new and different, but in the sense that you're probably documenting things in a new and different way than you did before. So we can keep going on that forever, but I think we need to move along to some other topics. But that's kind of one of the biggest developments that's going on right now. To shift gears a little and talk about enforcement updates, one of the things that the Trump administration and Assistant Secretary Aronowitz, the current head of EBSA, made a lot of noise about in his confirmation hearing was his pledge to reform DOL's enforcement efforts. He said he was going to stop cases that run on forever and just don't seem to have an end of the investigation in sight. He was going to stop having the agencies share information inappropriately with the trial bar. He said he was going to stop regulation through enforcement and instead do regulation by regulation. And just since the last time we got together, they put out a new field assistance bulletin, 2026-01, which publicly laid out his new enforcement policies. And what a FAB is, a field assistance bulletin, what that is sort of a public memo in which the head of the agency or one of the key leaders of the agency sends a memo to the rest of the agency telling them how to do things. So in this case, it's a memo from the assistant secretary telling everyone involved in ERISA enforcement at EBSA, here's what we're going to do and how we're going to do it. So first of all, it has four principles. The first one is we're going to focus on the bad actors. And what he's essentially saying there, if you read it, is we are going to prioritize those folks who are conflicted, who are charging inappropriate fees, who are, either taking benefits they shouldn't or doing things with benefits they shouldn't, benefiting themselves from this process. What we're not going to focus on is essentially second-guessing fiduciary judgment calls. In other words, if you've had a prudent fiduciary process and you've made a decision, rather than coming in and saying, well, would we have done it exactly the same way? They're going to focus the agency's resources on finding the people who are actually doing things wrong, as opposed to making judgment calls that are open to some potential disagreement. And I think for plan sponsors, that's good news, because that means we're going to be looking at, did you actually make a mistake? Did you actually violate one of these rules? Are your service providers taking money they're not supposed to take? Those are the kinds of investigations they're going to prioritize, not, well, your contributions withheld from payroll went to the plan in 5 days instead of 4. Was that really fast enough? Those are the kind of investigations they say they're not prioritizing. The second one is not doing regulation by enforcement. And the poster child for this has been employee stock ownership plans, ESOPs. For decades, DOL has made the policy governing how you value shares of an ESOP through enforcement settlements, through publicly released settlement agreements that have laid out some rules rather than by issuing regulations. And as we talked about last time, DOL has taken ESOPs off of its national enforcement priority list and is replacing that with a new regulation they're going to propose shortly, defining how to do that. So in all of these, basically they're saying, unless it's an unusual circumstance where some emerging issue is ahead of our regulatory agenda, we're going to be enforcing the regulations and guidance we've put out, not making it up by going after you in an enforcement case. Part and parcel of that is number 3, which is before the various parts of EBSA, the various regional offices start doing investigations into new and novel concepts and raising new issues, they're going to have to get approval from Washington. So sort of a tighter control over what types of investigations are going on. And the last of the 4 principles, which is one of the ones that I think is kind of most interesting, is being timely and responsive. There's been a lot of criticism of the agency for how many fewer investigations it's closed over the last 10 or 15 years. 15 years ago, they were closing 3,100 civil investigations a year. Now it's more like 800. And that was even before they had the big staff reduction that they've seen in the past year and a half or so. What they're saying now is, look, we should really have time limits on this. We should be doing these things efficiently. If we're going to do more with less, we have to have better guide rules. And so what they're saying is, for a routine investigation, it shouldn't take more than 18 months to resolve this. For a complex investigation, it shouldn't take more than 30. Now, I know some of you are probably looking at going 30 months. That's the better part of 3 years. And you're saying in a year and a half, that's how long it's going to take to do a routine investigation. Well, let me put it back to you. In my experience, as someone who's defended people in DOL investigations, I've had them go on 6 years before. So this is an improvement, and it is an important statement to the agency that we need to keep these things moving and resolve them, not let them linger over long periods of time. And the last kind of major thing we thought we'd talk about here today is the guidance DOL recently put out in the technical release 2026-01, which dealt with proxy voting. And there's kind of 2 things going on here. One is this broader issue of ESG investing, environmental social governance, or what some critics, including the Trump administration, call woke investing. Across the board, the Trump administration has been very critical, especially in ERISA, of making investment decisions for any reason other than the economic interests of the participants in their retirement income. In other words, they've been very vocal about saying, we don't want you engaging in politics or social good with your investments in ERISA, your investments in ERISA plans. ERISA plans are about creating retirement income for workers. It's about you making investment decisions for investment reasons, not other reasons. And that's been kind of a big theme. The proxy voting issue is similar to that. And the reason it's adjacent to that issue is that DOL is saying, hey, you should be aware that it is fiduciary obligation. It is a fiduciary duty to vote the shares pertinent to your investments. In other words, where your investments in a plan have voting rights, it's a fiduciary decision to decide whether and how to vote those. And they went on to say, and proxy advisory firms who help you do that may be investment advice fiduciaries to you. If they're telling you how you should vote, they may be fiduciaries for that as well. So you, as the plan committee, have a fiduciary obligation to understand how those shares are being voted and to ensure that they're being voted in a manner consistent with ERISA. And kind of the backstory here is there's been criticism, again, particularly from the Trump administration, that proxy voting services may have other political or other goals, not just economic goals. And they're really trying to say that's not something we want to see happening in ERISA. So this new guidance basically says, hey, this is fiduciary, pay attention to it, and make sure your proxies are being voted in a manner that's appropriate. The other thing they said in this release is, by the way, there are states out there that have been putting in place reporting requirements so that if an investment manager is voting shares for reasons other than economics, they may have to disclose that under certain state laws. DOL was taking the opportunity here to say those state laws are not preempted. In other words, because ERISA plans aren't supposed to do this in the first place, a state law that requires disclosure where that happens doesn't run afoul of ERISA. Now, that's kind of an odd interpretation, frankly, of ERISA preemption. It's a little different than what they've historically used. But the broader issue here, and I think this is one that it's just a good time to remind plans about it, you may not have to worry about voting the shares. For example, if you own shares of a mutual fund in your plan, you're not the ones voting the shares of the mutual fund in most cases. There are other investments where the plan holds them directly, where they are going to be responsible for voting them or for having another fiduciary vote them for you. It's probably worth just reviewing with your investment advisor, do we have this issue? And if we do, how are those shares being voted? So that if DOL were to follow up on this, you'd be able to say, we know what's going on and we've taken the appropriate steps to deal with it. I don't know that DOL has broken really new ground with this announcement, but it has served to focus their efforts again on this broader issue. And it's one that I think plan fiduciaries should just be aware of, that DOL in the Trump administration cares about very much, and probably more things here are going to happen. We could keep on going because DOL certainly is, but I think that's probably enough for us for this particular podcast, quarterly update, whatever you want to call it. I want to thank you all for joining us. And hopefully we got to most of the questions as they were coming in, but the ones that didn't, we'll try and get back to you on those as we go through. So Amber, let me turn it back over to you.
Thank you. On behalf of Hub International, thank you for attending today's webinar. As a reminder, we ask that you please fill out the exit survey before you close your browser. Your feedback helps us as we develop future webinars. This now concludes our broadcast. Thank you and have a great rest of your day.
Thanks, everybody.